If you are unconscious in a hospital and cannot speak for yourself, who gets to decide whether you stay alive? This question reached the Supreme Court of Canada in Cuthbertson v. Rasouli in 2013. In 2010, 61-year-old Hassan Rasouli underwent brain surgery in Toronto. After complications, he suffered severe brain damage and became unconscious, kept alive only by mechanical ventilation and artificial nutrition. Without this life support, he would die. His doctors believed he was in a persistent vegetative state, that treatment was ineffective, and wanted to withdraw life support and move him to palliative care. But his wife, who is his legal substitute decision maker under Ontario's Healthcare Consent Act, refused. She believed, based on his religious values, that he would want to be kept alive. This created a conflict between medical judgment and family decision making, where the patient could not speak for himself. The key legal question was whether withdrawing life support counts as treatment under Ontario's Healthcare Consent Act. The Supreme Court, in a 5-2 decision, said yes. The court defined treatment broadly as anything done for health-related purposes, including palliative care at the end of life. So even if doctors believe treatment is medically ineffective, they still need consent before withdrawing it. So doctors cannot act unilaterally. If consent is refused, they must dispute it to the Consent and Capacity Board, which can override a decision maker if they're not acting in the patient's best interest under Section 21. 2 justices dissented, arguing these decisions should be handled by courts instead, but the majority decision governs in Ontario. This case directly affects you. If you lose capacity, someone else will make medical decisions for you. If you haven't formally chosen someone, the law assigns a decision maker using a set hierarchy. That person must follow your prior wishes or act in your best interest based on your values and condition. In this case, Mr. Rasouli had no clearly documented wishes, which caused this conflict. So the key takeaway is document your wishes while you are capable. This can include naming someone in a power of attorney for personal care or having clear conversations with your family and loved ones. This case also protects you because it ensures that doctors cannot make these decisions alone without a legal process. This case reshaped how the healthcare system handles end-of-life decisions. It moves decision-making away from individual physicians and into a legal process through the Consent and Capacity Board, balancing medical judgment, patient autonomy, and family involvement. But it also raises ongoing issues, including ethical strain on doctors, ICU resource pressures, and the lack of consistent rules across provinces. At the end of the day, Cuthbertson versus Rasouli shows how law, medicine, and personal values intersect, and just in case something happens, your wishes should be on record.